Hey, this is Dan Kraus. We're going to be starting in about 2 minutes. I just wanted to get on and welcome everyone. I invite you to put any of your questions in the sidebar. There should be a place for you to um, chat there. Also, Laura will be adding questions for people to answer if you wouldn't mind doing some polls and giving some handouts in the presentation. If you can't see me or if you can't see the slides right now, you can scroll probably up or down or maybe to the side. You should be able to see me and the slides. I am going to turn off my camera here for the last minute before the presentation, so you won't be able to see or hear me then for another minute. So I will be right back and look forward to this presentation. Okay, I'm back, and we are going to begin the presentation. It is 11 a.m. Central Time. Thank you for the people who are here, and once again, there is an opportunity to chat. There's a chat function in the presentation. Hopefully you can find that. There's also some handouts that Laura is going to be putting in the handouts area, and she will also be creating some polls, I think. We do not hand out the slides. The slides are not something that we want to see other people presenting. So the slides will not be handed out, but there will be some information that is put out. So hopefully, also there will be a recording, so you can listen to this as many times as you want. I'm not sure exactly where the recording is going to be posted, but Laura can maybe answer that. Okay. Well, it looks like everybody's going to receive a link to the presentation. Good. There we go. All right. So today I want to talk about planning for Medicaid. Don't lose everything you've worked for. My name is Dan Kraus. I am an attorney. I practice estate planning and elder law, mainly in Wisconsin, though I am licensed in Illinois and Minnesota as well. So some of the things that we're going to be talking about are going to be talking specifically about Wisconsin rules. Medicaid rules depend on the state. Medicaid is a federal program, but it's administered by the states, and every state has different rules. So the rules that we're going to be focusing on are Wisconsin rules. Most of them are general rules, and they vary a little bit state to state. Some of them vary quite a bit, and I am not able to answer in-depth questions about other states besides Wisconsin. Okay, so a little bit about me. I am a retired Army JAG officer. There's a photo of me in one of my green uniforms back in the day with my BCGs on, and BCGs for military parlance, that's also known as birth control glasses. So the BCGs are the glasses that the Army gives you, and nobody ever wants to go on a date with you. That's why they got the nickname BCGs. I have 25 years of estate planning experience. I am actually a certified specialist, one of only 7 certified estate planning law specialists in Wisconsin. And I also did a little stint in the Peace Corps. I wrote a book called Estate Planning in Wisconsin, Privacy, Protection, and Taking Control. And let's get into the meat of our presentation. All right. So long-term care. Is long-term care a concern? Well, for most people, it's something that we don't know whether we're ever going to need, but the statistics tell a little bit of a story. Statistics as of 2022, they say that anyone who reaches the age of 65, they have more than half a chance of ending up in a nursing facility for at least some period of time during their lifetime, during the rest of their lifetime. When you get to be 66, that percentage goes up, and 67, etc. As you age, the likelihood of you spending some time in a long-term care facility goes up. Some of the dangers that we have of getting older, and some things that can cause us to end up in a nursing facility or an assisted living facility, or unable to manage our own affairs. Many kinds of dementia, Alzheimer's, specifically Parkinson's, crippling arthritis, feebleness of old age, COPD. These are things that make it hard for a person to manage their own affairs, so that someone has to help them on a day-to-day basis to take care of themselves. Long-term care is expensive. Costs a lot of money in order to help somebody live their day-to-day life. If you have a home health aide and you pay them around the clock for 24 hours of care, it means that you're going to have more than one aide so that they can have shifts, but that can be up over $200,000 a year. Assisted living, depending on the facility and depending on your needs, can be $60,000 a year or more. And memory care is one type of assisted living, and that can be much more expensive. In fact, it can be more expensive even than a nursing home, depending, like I say, on the needs of the person and the particular facility. Now, nursing home is about $156,000 a year in Dane County and Milwaukee County, and it's going up. It may be higher than that by now. I haven't checked in a few months what the average cost of nursing care is, but it has risen an average of 3 to 4% annually. Now, that 3 to 4% is averaged over the last 20 or so years, so we know that inflation has been higher than that recently. It does go up generally faster than inflation. So we know the cost of long-term care, or at least some of the cost of long-term care. Who pays? Who pays that cost? Well, it's not Medicare, and it's not health insurance. Normal health insurance will not pay long-term care costs. So who does pay? Long-term care insurance. If you're lucky enough to have a long-term care insurance policy, the idea behind that policy is it pays if you need long-term care. Now, different policies have different rules, and some will only pay in a nursing home. Others will pay for home care. Many of them have spending limits, so once you hit the limit, there's no more insurance. Almost all of them have daily limits, so that you can only have so many dollars per day for a benefit, and then if your care costs more than that, then you have to make up the difference. A VA pension is available to some members of the military, depending on when they served, but and many people know this as aid in attendance, but it will not cover the full cost of most long-term care. The maximum you can get is $31,000 a year, and many people get much less than that. Medicaid, not Medicare, Medicaid is another program that will pay for long-term care insurance. So this is a government insurance program that we all pay for out of our taxes, and that pays for long-term care. And otherwise, without any of these other things, people are stuck with out-of-pocket payments for long-term care. So bottom line for most people is you pay for long-term care until you go broke. And once you go broke, then Medicaid pays. So this brings up a basic inequality in our healthcare system in this country. The U.S. healthcare system discriminates against people, discriminates in favor of some people and against other people, not because of the color of their skin or the race, ethnicity, religion, etc. They discriminate based on what kind of illness you might have. Doesn't seem right. Medicare is something that all of us get. Well, all of us, as long as we are a citizen or permanent resident and we've paid into the system, once we get to be 65, Medicare is health insurance that we no longer really have to pay for. It is some reimbursement is taken out of our Social Security checks, but it doesn't really cover the whole cost of the care because we've paid for it from our taxes. So we do get a small payment out of Social Security, which is required to pay for Medicare, and then all of us have it or will have it. Even billionaires. It doesn't matter what your income or asset are, you're going to have Medicare at 65. But that doesn't really help you because if you need long-term care, it won't pay. So Medicaid is a needs-based program, which means you have to go broke before Medicaid will pay. So Medicaid is only available to those people who meet certain financial requirements. Billionaires are not going to meet this requirement, and anybody with too many assets is not going to meet this requirement. So back to the discrimination. What do I mean by discrimination? Why is there discrimination? Well, there's discrimination in the fact that you might need health care, and depending on what your malady or your ailment is, government's either going to pay or you have to go broke. So let's take a look and see who gets the favorable discrimination. Well, anybody with cancer, heart transplant, bypass surgery, dialysis, or stroke is going to have care in a hospital or an outpatient setting. That is all covered by Medicare, so you do not have to go broke. People with Alzheimer's, Parkinson's, COPD, debilitating arthritis, and post-stroke disability that need help caring for themselves for the rest of their lives need long-term care, and you have to go broke before you can get the government insurance. Why is that? Well, somebody drew a line at some point in the legislation when they set up these programs that said Medicare only pays for certain things and Medicaid pays for other things. And what that means is if you are unlucky enough to have one of the ailments on the right-hand side of this chart, then you get to be discriminated against and you have to go broke at the end of life. If you're lucky enough, now I don't really mean that a person that gets cancer is lucky, but compared to someone with Alzheimer's, financially, they are very lucky because their Medicare insurance is going to pay, and then their Medicare supplement is going to take care of the rest. They do not have to go broke. So what's the government's plan? If you need long-term care, there's a spend down that has to happen, or doesn't really have to happen, but this is the government's plan for you. There is a spend down. That means if you go into a nursing home, you essentially have to pay for things out of your own pocket until you get to a point where you have $2,000 or less. You can keep your home as long as you check the right box on the Medicaid application. You can have one car. Even if you're a couple only is allowed one car. And you can have burial insurance or irrevocable insurance that pays the funeral home after you've passed away. Those are pretty much all the assets besides just the knickknacks and things in your home. So homes, goods and furnishings and homes, they don't count either. Now you say, well, my home is my biggest asset, so that's great. I can keep my home. But there is also another part of the government's plan that is called estate recovery. So besides the spend down where you have to spend for your own care, after you die, the government, the state in this case, comes back after your home. If there is a home there, if you've kept the home during your stay in a nursing facility, the government will put a lien on that home, foreclose on the lien, and your family will have to sell the home in order to pay the lien off. And they might take the whole home, but it depends on how big of a tab you've built up with Medicaid. So if Medicaid is paying for your care, they are keeping a tab. They know how much they've paid for you, and then after you die, they will try to recover on any assets that are available. Okay, so we've talked about the cost of nursing care. 5 years of cost of nursing care will eat up about $780,000. Long-term care insurance pays part of the nursing care. If you've got a really, really good policy, then it will pay for all of it, but there's very few of those policies. And if you have one like that, you probably got it a couple decades ago or more, because they don't really offer these policies anymore. There are limits. And if you've waited until you're in your 60s to buy this long-term care insurance, it's going to be expensive and possibly not available for you, because they do check your medical history. They price it based on age and your likelihood, of course, of going into a nursing facility. All right. So here's another illustration of the government's plan. Let's say Dad started out with $300,000 put away for his retirement and his home. So let's say the home is worth about $300,000 as well. So what happens in the government's plan, if Dad goes into a nursing facility, he pays out the $300,000 for nursing home expenses, depending on how long he's there. Now he really only have to pay $298,000 because he's allowed to keep $2,000 in the end. But rounding is easy in this case, so let's just say all $300,000 goes for a nursing home expense. Then when he dies, if his expenses go on beyond that $300,000, Medicaid keeps a tab, and then they come after the home and they take the home to pay the tab. So in the end, Dad has no security during his nursing home stay once the money is spent. And then the kids get nothing in the end because the state comes and gets the home. So what can you do? This sounds just terribly depressing. But if you know the rules, or you know somebody, you have a friend who knows the rules, and we'd love to be your friend in this, it does not have to be that way for you and your family. So we work within the rules. Elder law is within the law. It is not cheating. We're not doing anything that's illegal. We're not doing anything that's not proper, not immoral, because of the discrimination that's inherent in the system. This is a proper thing for people to do. Try to save your assets. Take advantage of the government insurance. One important thing that I want to emphasize: in order to do much of this planning, in order to do the planning that's going to save your family these assets, you really have to have a family member, usually a child or more than one child, who is very trusted by you, because you're going to have to hand over assets to them and trust that they are going to save them for your security, instead of dipping their hands into it while you're living. So the smart plan, if you know the rules: keep your house or your farm for your kids. Keep most of your money set aside for your security, and use Medicaid to pay for your care, or to pay as much of your care as you can get them to pay. How do you do that? Well, let's talk about some concept with Medicaid planning. So Medicaid planning has a spend down that they expect you to do. Part of that spend down is you want to have less that you need to spend down. So how do you do that? Well, you can spend on yourself, but a better thing to keep your family in the loop and to allow them to have these assets and control of these assets is to do some divestment. Divestment is what they call in the Medicaid handbook, but it's gifting. It's giving your things away. Any gifts within 5 years before a Medicaid application creates a penalty. So this is the 5-year look back period that people may have heard of. If you give away anything within the last 5 years, and then you make an application for Medicaid, the triggering date is your Medicaid application submission. If you submit that Medicaid application 4 years, 11 months, and 29 days after you've made a large gift, you're going to get penalized. If you wait 2 more days to make that Medicaid application, then the 5 years will have passed and it's not going to give you any penalty. 5 years, very important to understand. Now, this gifting or divestment includes any transfer for less than fair market value. So many families get together and they try to get around the rules. They don't know the rules very well, and they think, well, what if my child buys my house for $100? Then I'm not giving a gift. I actually sold the house. Well, the state is a little smarter than that, and it doesn't work, unfortunately. There are some gifts that are not counted for divestment. You're not penalized for these gifts. You can give assets to a spouse, unlimited. You can also give assets to a disabled child or a special needs trust. So what's the penalty for gifting? If you give something away within the last 5 years, the penalty does not depend on when you gave it away. It's any time within that 5 years. So your penalty is the same if you gave it away yesterday and then you apply today for Medicaid, or if you gave it away 4.5 years ago, you have the same penalty. So you take the amount of the gift and you divide it by the penalty divisor, and that tells you how many months you're going to be disqualified from receiving Medicaid. Now, another thing that they've done is they said, well, you can't start your penalty until you've otherwise qualified for Medicaid. So what does this mean? It means you have to get your assets down to below $2,000 before they will even start the penalty period. So essentially, you have to give everything away and then start paying for your care through the penalty period, which is a difficult trick. But it's a trick we know how to do. So let's just give an example. If you give away $170,000, whether it's savings, whether it's your house or other real estate in Wisconsin, and then you apply for Medicaid sometime within that 5-year period, what's the penalty? Well, in this case, Wisconsin's penalty divisor this year, $9,599.80. So you just divide 170,000 divided by 95.99. You get to 17, round up 18 months of penalty. So that means after you made your application, the state will say, okay, it looks like you qualify for Medicaid because you're now down below $2,000 and you meet the other applications, but the application requirements, but you gave something away. So you'll have to wait 18 months before we will give you any Medicaid benefits. I want to caution people. Today, I'm giving you a lesson on Medicaid. It's not everything. There's a lot to know about this. There's a lot of ins and outs, and people can make mistakes if they know enough to be dangerous. Be careful, and this is what many people do. Be careful about gifting things directly to your kids in order to save them, in order to do this divestment. If you want to give your house to your kids and then wait 5 years, and hopefully you make it for 5 years, and then you might need Medicaid later, there are some pitfalls to giving the house to the kids now. You got the 5-year look back, but you can't get around that. However, if your child dies and you're still in the house, you got to be careful because that house can be lost, meaning that it will go to your child's kids, your child's spouse. It could go to pay your child's debts. If they died with debts, the house would have to be sold to pay their debts. And now you're out of a house. If the child that you give the asset to divorces, your house can be split, and now you're dealing with an ex in-law that owns your house or owns half of your house. That could be just a nightmare scenario. If your child has their own financial problems, if they go bankrupt for whatever reason, they might have health concerns and they have a lot of doctor's bills. They might have a business that goes bad. They need and then they go bankrupt. Your house now is going to be part of the bankruptcy, and you might lose it that way. The final thing that you got to be careful about, if you give assets to a child during your lifetime, capital gains tax problem, especially for real estate. Stocks and bonds are also an issue. Cash is not so much an issue here, but real estate or stocks and bonds. If you give something to a child during your lifetime, they inherit your basis, your tax basis in the property. So if you give the house directly to the kids receive the house at your tax basis. So let's just imagine mom and dad bought a house in the 80s for $80,000. Now it's worth $350,000. Well, let's make it easy. Now it's worth $380,000. The difference between what they bought it for and what it's worth now is capital gains. That's $300,000 worth of capital gains. When your children sell that house after your death, they are going to have to pay capital gains tax 20 to 30% on the gains in that house. So we're talking about $300,000. 20% of $300,000 is $60,000. Kids are going to have to pay $60,000 or more in capital gains tax. This can be avoided. How do you avoid it? Instead of giving the asset to your kids right away, you create an irrevocable trust. These types of irrevocable trusts that we do all the time here are called MAPT, or Medicaid Asset Protection Trust. It has the same 5-year look back, so it's not an advantage there. However, your family is protected from your kids' divorces. These assets are protected from your kids' bankruptcies, or even if your kid dies. The assets will remain in the trust. They're secure. They can't be taken for other people's debts at this point. Also, beautiful thing about this, if the trust is drafted correctly, I want to emphasize this. If the trust is drafted correctly, you and your family will get a capital gains tax advantage. You won't have to pay any capital gains tax if the kids sell the asset after you die. The assets get what they call a step up in basis to the date of death value. So even though you paid $80,000 for that house and you die when it's worth $380,000, the death, if the trust is drafted correctly, steps up the basis so that now the house is worth, for tax values, $380,000. So if you sell it right away, there's no capital gains. Also, the thing about keeping it in the trust is if your family cooperates, you can get the asset back if needed, if there's some emergency, etc. You don't have to worry about something happening to your child if they die or become incapacitated. All right, so we saw what the government's plan was. Here's just a little illustration of what pre-planning is. So now we do pre-planning and crisis planning for Medicaid. Pre-planning is when you believe you're probably going to have 5 years, okay, because of that 5-year look-back period. So here's Dad's example again. He's got a $300,000 nest egg and a $300,000 house. What does he do? Well, if he's aggressive with his planning, he puts his house and $225,000 of those $300,000 into this irrevocable trust called an MAPT. After doing that transfer, he has to turn over control of those assets to a trusted child. And then they can hold it for him for his security and get some out in emergencies if he needs it. Then he keeps the rest of the $75,000 just in his bank account. And so that he has some, mad money, spending money. He can repair his home. He can take vacations, whatever. He's got a little bit of money there. Then, let's say 6 years later, he needs a, 6 years later, he needs a nursing home. So he goes into the nursing home, and the $75,000 that he kept for his pocket goes to pay for his care. But the house and the $225,000 remains in the Medicaid Asset Protection Trust for security during his stay in a nursing facility. So he's got that. The children manage it, and they can take money out and pay for things for him. If he needs extra massages, if he needs a big screen TV, if he wants to go to vacation, if he wants to pay for all the grandkids to come and see him, all that money is available for all of those things instead of being paid for his care. Then, upon his death, everything goes to the kids. Whatever is left in that irrevocable trust goes to the kids. And another nice thing about this is that irrevocable trust is not responsible for paying any of his expenses. He doesn't have to pay off his credit card. It doesn't have to go towards his funeral. It doesn't have to go to anything except for the kids or his chosen beneficiaries. Doesn't have to be kids. Normally it is, though. All right. So in that case, a pre-planning started with $600,000. 525 of that was saved for the family. Only 75,000 had to be used for dad's care. Now, we also do some crisis planning, and this is a situation with mom's plan. So something happened. Mom did not do any pre-planning 5 years before, and now it's time for mom needs nursing care. She needs to get into a nursing home, or it's possible that she's already in a nursing home and she's been private paying for a year or more, but she still has assets left. We can still do crisis planning. It's not too late. So what do? We have the same assets, $300,000 nest egg and a $300,000 home. Because she needs immediate assistance, we can't save as much as we could for dad, but we can still save a significant amount for mom's security and then inheritance for the kids. How do we do that? Well, we use a specialized kind of annuity called a Medicaid compliant annuity, and we use the same irrevocable trust, MAPT, and we split the assets between these two. Whatever we put in the annuity is what we lose towards care. So we have to do it that way because the gift that we've made to the irrevocable trust, the gift that we made to the irrevocable trust is going to be less than 5 years from the time that mom applies for Medicaid, because we're going to do this. It's a crisis. We got to get her on Medicaid as soon as we can. So the assets that go into the irrevocable trust create a penalty period. We do all the calculations. We decide that this is how much we can put in the irrevocable trust, and therefore this is what the penalty period is going to be. And so we know that this much is how much we have to put into the annuity, because the annuity pays through the penalty period. So as the annuity pays out month by month, it pays out just enough to pay for mom's nursing care during that time that she is penalized. Now we've created the calculation so closely that as soon as that annuity is up and there's no more money, mom's penalty period is over and she goes right on to Medicaid. And so we've saved essentially $325,000 of mom's assets because we did this crisis plan instead of using the government's plan. If we remember, the government's plan is you spend everything and then you come after the house after death. In this plan, mom has saved $325,000 for her security, and after she's gone, that goes to her family. So I'm just wrapping up my portion of the lecture here. I'd like to get to your questions if you've got any. So I just want to remind, if you plan poorly, you might end up like this poor guy with a cardboard box and no good health care. And if you plan well, you might not know where you're at or what year it is, but you're going to be happy. You'll be dressed well, and you'll have a nice set of headphones to boogie down. So with that, I will go into the chat and see what we've got. Thank you, by the way, for any questions or things. And we don't have too many right now. Let's see. I'm the power of attorney financial for my mother, soon to be 80 years old. My brother was assigned medical power of attorney. My mom's attorney that drafted documents has retired. We need to remove him from medical power of attorney and assign to me. Is this simple process? What's the cost? That depends. This all depends on whether your mother is competent. Now, I just want to emphasize that I'm going to be talking in general terms. This is not legal advice for you. It's just talking about a general situation. It may not fit your situation. There's many factors that I don't know about, and you're not my client. So I'm not giving you advice. I'm just talking about a general situation here, okay? Just to be clear. If mom is still competent and she can still sign new documents, all you have to do is get new documents. She signs those and they usurp the old documents, or they take the place of the old documents. If mom does not have the ability to sign documents anymore, then it's too late. You can't do anything unless your brother cooperates. If your brother cooperates and he would agree to resign, hopefully your mom listed you as a secondary. If your mom did not list you as a secondary, then you're out of luck. If she's incompetent and she has no secondary, or somebody else besides you as a secondary from your brother on that power of attorney for healthcare, unfortunately, there's nothing you can do to get a new power of attorney for healthcare. Also, I want to caution people, if you've got a power of attorney for finance, it's very important. That's great. Good on you. However, if you're relying on that power of attorney to help somebody else avoid Medicaid or avoid nursing home costs so that they can qualify for Medicaid, if you're doing these crisis plans or pre-plans, the power of attorney might not be adequate. You have to have certain language in that power of attorney that allows you to gift things, to create a trust, to gift things to the agent. It's stuff that people come to me and they say, we need to do this planning for mom. Here's the power of attorney. And I look at the power of attorney and I say, oh no, we can't do this. The power of attorney that your mom signed is not adequate. So I see these powers of attorney all the time. They're sometimes drafted by attorneys, but sometimes they're forms that people have downloaded from the website, some website, and they don't work. So be careful about the power of attorney. What does it cost? This is something that it really depends on where you go. Some places will just do a power of attorney for you. You can download them off the internet. That's free. You can pay for ones on the internet. That would cost you whatever it costs. If you come here, I would have to take a look at your entire situation and advise you on what I think you should do, and then we could discuss cost at that time. So I'm sorry I can't give you a better answer about the cost, but the real answer is it depends. Okay. So there was a question: wouldn't it make sense to put all $300,000 in the MAPT versus keeping $75,000 out? Well, for some people it might make sense. However, anything that goes in the MAPT you cannot use for day-to-day expenses. You have to have at least one bank account where your Social Security or your other income goes into it that cannot be in this irrevocable trust, cannot be in the MAPT. I usually counsel people to keep enough out that they're comfortable with it. The reason why I give that example instead of just saying keep $10,000 or $5,000 out for your monthly expenses is because most people, after saving their entire lives, and they're fairly healthy still, because this is pre-planning. We got to be pretty sure that you're going to make it 5 years. They're not ready to give up control of everything. Imagine if someone asked you to put all of your assets except for $5,000 in someone else's control, and you couldn't have it unless they agreed. That's the issue. So yes, $75,000 is just an example. Could be less, could be more, but at least it's something. So good question. I would not recommend putting the entire $300,000 into the MAPT because the person that's doing it will not have freedom to access that money as they need it. Okay. Can they take the house if both mom and dad are on the house and one is still living in the house when the spouse is in the nursing home when they die? They cannot take the house. They will not, the state will not enforce a lien on the house while either spouse is living. Okay, good question. The one living in the house never goes to a nursing home and dies, then the state takes it. Yes, that's correct. The state will wait till both parties have passed and then go after collecting on the house. Can a trust work for an IRA or a 401k? That is one very good question, and the answer is no. You cannot put a 401k or an IRA into one of these MAPTs. It's just not allowed. The federal rules say those have to be in an individual's name, so they cannot be protected. The only way we can protect those things is if you cash them out or you change them from an IRA just into a regular investment account. Then you have to pay all the taxes. So it's difficult to protect an IRA or 401k. Normally, we tell people if you're looking at trying to save assets, start spending more out of your IRAs. If you're old enough to start spending from your IRAs and building up cash somewhere else, then do that. You're going to have more taxes during the years that you're spending out of your IRA, but you can protect the assets that you're saving because of that. Can a trust work if you still have a mortgage on your home? That also is a very good question. You can put your home into an irrevocable trust, but there is a risk if you have a mortgage on it that the bank will call the due on transfer clause. So every mortgage these days from a bank is going to have a clause in there called the due on transfer clause. Now, the due on transfer clause says that if you transfer the house, you have to pay the mortgage immediately. Well, that makes sense, I guess, because the bank gave you the loan and didn't give the new owner the loan. However, oftentimes we can work with banks, especially local banks, and say, hey, this is what the clients want to do. They want to create this MAPT, put the house into the MAPT. Will you enforce the due on, hiccups. Will you enforce the due on transfer clause? We ask the bank. And the local banks, a lot of times they will say, no, do that. We think it's a great idea. The banks don't lose any security. They can still foreclose on the loan and get their money back. If you don't pay the mortgage, they can still get payments from you. And if you stop paying, they can get the home. It doesn't hurt them. So that's why they will agree. But we found that the big banks, if you ask them, will always say, no, you can't do it, which is why sometimes our clients decide to take the risk because the banks don't monitor that. So also there is a federal rule. It's not clear, and it's something that you might have to argue to the bank that the federal rule covers these types of trusts, and it makes it so the bank cannot enforce the due on sale clause or the due on transfer clause. It's a little bit complicated, but that's a good question. It's best and most secure if you have no mortgage on your house. Although we have many clients who do have mortgages on their house, putting them into Medicaid Asset Protection Trust, and knock on wood, the banks have never come after the due on transfer clause. So I'm not telling you that they can't. I'm telling you that it's rare, and you should consult with somebody who's experienced in this area before doing that. Okay. What about the revocable trust instead of an irrevocable trust? So just to segue from the last question, a revocable trust, you can put a house with a mortgage in a revocable trust and there's no problems. The federal law clearly covers transfers to a revocable trust, and they forbid the enforcement of the due on transfer clause. However, to an irrevocable trust, it's not as clear. So can you put your house into a revocable trust? Yes, but it will not protect a single shingle from nursing costs. Let me say that again. If you put your house into a revocable trust, there's no protection from nursing costs. It has to be an irrevocable trust. Now, I want to just do a caveat because I don't want everybody taking their houses out of revocable trust. If your house has been in a revocable trust since before 2014, they changed the law, but they did grandfather the law in so that if you keep your home in a revocable trust and it's been there since the trust was set up prior to August 1st of 2014, then the state has promised not to collect against the house. So they will not do the recovery, the estate recovery against the house, if it's in a trust before 2014, August 1st of 2014. So that's a very important date. When they changed the law, Wisconsin now has enhanced recovery. They will recover against it unless you meet that requirement, 2014 requirement. All right, let's see. I'm 75 and my husband is 85. We have a revocable trust. What do we need to do to secure our assets? Well, it depends on, like I said, what we talked about, that the 2014 rule. If the house is titled in the revocable trust and the revocable trust is dated before August 1st of 2014, you may be okay with the house. You just make sure that you don't sell it, you don't take any mortgages out on it, that it stays in that trust, and at least the house at that point can go to your kids, even if you're staying in a nursing home for a while. The key is, if you have to apply for Medicaid or somebody has to apply on your behalf, they need to check that box on the form that says intends to return home. Now, it might be impossible for you to return home, but that box needs to be checked either way. So it's important that you fill out the Medicaid application properly. Otherwise, they will force you to sell the house to pay for your care. Okay? So just keep that in mind. All right. But otherwise, if your revocable trust is after August 1st, 2014, you just need to set up an appointment with a good elder law attorney and talk with them about this. What do you need to do to secure your assets? That all depends on a lot of things. How's your health? How many assets do you have? What types of assets do you have? Is one of you more likely than the other to be in the nursing facility? What's your family history? That comes into it a lot. Some families, the people die of heart attacks, and you can almost predict it. It's not saying that it's fate, but it's a predictor. In some families, there's a lot of nursing home stays because of Alzheimer's or other dementia. So there's more risk or less risk in different families. So that's something that you would have to talk to an attorney about. Hopefully somebody who is experienced in elder law and Medicaid planning. How much will it cost to change if needed? It depends on the plan, but it may be as well. Let's just say I do some things for people. We can add some things on here, but the minimum cost is probably about $4,000. And it can go up to several, say 12, 14, $15,000, depending on the assets, depending on the amount of work that we need to do. If you come to our firm, we can sit down with you and we can tell you exactly what it's going to cost before you decide to sign on. But it all depends on a lot of those factors. If you take funds from an IRA account, can you add to MAPT monthly or annually? You can. The issue with that is the 5-year look-back period. Every time you put something into the MAPT, 5-year look-back period is triggered on that gift or that transfer. So anything that you put in there 5 years ago, you don't have to worry about. But something that you put in there every month, that gift is going to work its way through the 5 years, and then each month will fall off the end and not be counted. But you're going to have a lot of gifts in that 5-year window if you do it monthly. You can. It's just a matter of what's going to happen if you apply for Medicaid. There's going to be some penalties because you're going to have monthly gifts for 5 years in that you have to count and get penalized for. All right, so that is the last question that I see. Is there another one? Hopefully. These polls are great. So if you have a chance to answer the polls, please look in the polls section. I don't know where you'll find it, but I think if you, on my screen, the chat and the polls are just different parts of the same thing. If you want to answer those. But otherwise, I'm just going to wrap this up. We did not quite take an hour. It's 50 minutes into the hour. I hope you learned something. Once again, my name is Dan Kraus. I am an estate planning and elder law attorney. I practice in Wisconsin. We have offices in Brookfield, Madison, and Oregon, Wisconsin. And I would love to help you to see whether you can save assets from the devastating costs of nursing care if that ever comes up in your family. If you have parents that are in that situation, even if they're already in a nursing home, sometimes we can save some assets for their security and then for their beneficiaries when they pass away. Thank you for taking your time with us today. You will get a link to the presentation. You can watch it with whomever you want or share it. And I would appreciate if you did that. Tell your friends. If you know people that need this stuff, we're happy to help them. All right. Everybody have a great day. Stay well. And I hope you never need nursing care.